about the maintenance, that landmark judgment under the section 125 CRPC or related to maintenance order, the very first case which comes in our mind is the Muhammad Ahmad Khan versus Shah Banu Begum, and where the Supreme Court hold that this, since CRPC is a secular law, it is a social welfare provision, and therefore the women, that is the wife of every religion, irrespective of the religion, be it she is the Hindu, she is Islamic, or she is of any other religion, she will be getting the maintenance under this section. So therefore, in this particular case, the Shah Banu Begum was given the maintenance order in her favor. Now the question comes that who will be the wife considered under the section 125 CRPC. So for this we have this another case, that is the Somalia versus Viva Kosha, and this was the case of year 2005, where the Supreme Court ruled that the wife for the purpose of section 125 must be the lawfully married, that is the woman who is not lawfully married cannot claim maintenance, that is you have to prove that the marriage was the valid marriage, and then only you will be entitled for the maintenance, that is under section 125 service. So you have to prove that this marriage was the valid marriage, then only those wives will come under the section 125 and they will be entitled for the maintenance. Now the other question which comes in our mind is related to the this time limit. It is the what will be the time duration of the maintenance? Will she be getting the maintenance throughout her life, or is there any limitation? So for this we have this another case, that is the Mutaj Singh versus Srimati Ramendri. In this particular case, the Supreme Court ruled that to enjoy the status of wife under section 125, that is if you want to get the maintenance order under section 125, you have to prove that you are not remarried, or till the time you are not remarried, then till the time you are not remarried, you will be entitled for the maintenance, and the moment you will remarry, the maintenance order will not be given, and so therefore we can see that there is a limitation that throughout the wife who is not remarrying, till that time she is not remarrying, she will be entitled for the maintenance. Now I have seen that who will be the wife who will be getting this maintenance under section 125. But now the other question, this is a very famous case, that is the Basha versus Urmila Basha Bhosle. This was the case of 2014. This is also known as Basha versus Basha case. And in this case, what was held that the second wife was given the maintenance. It's not that the bigamy is allowed; it is prohibited. But the fact was that this husband has concealed the fact that he is already married, and the marriage was still existing. Because of this particular reason, the second wife was given the order to maintenance, because she was unaware of the fact that the husband was already married. Therefore, in this particular case also, the second wife was was given the maintenance order and in her favor, and she was entitled for the maintenance. Now another question comes which is very prevalent in our society, like what if the woman is unmarried? What if the wife is in? So for this we have this two we have this tag of the Supreme Court judgment also. So we can see that in this particular case, that is the case of Sunita Kachwa versus Anika Shwaha. This was the case of 2014, and similarly the other case, that is the Chaturved versus Sita by 2008 case. In both of these cases, the Supreme Court ruled that if the income of the wife, even if she is earning, but the income of the wife is insufficient to maintain the standard of her living, that is the standard of living which she was accustomed to, if the particular amount is insufficient for her, similarly you can see this another case also, that is the Sunita Kachwa case. In this also the court hold that if her earning enable her to maintain herself in the standard, that is the standard of living, that is the standard thing. If you have to focus on this particular thing, that is the standard wala. So if she is unable to maintain her standard of living which she was accustomed to, then she will be entitled for the the standard of living which she was accustomed to, she will be entitled for the maintenance under this provision. Now the other things which comes in our mind is the related to the issue that, since as we all know that we have this various act, is the if we talk about the Hindu, we have this CIPC will be that was the secular law, but we have this another act if we talk about the Hindu, that is the Hindu Minority, Hindu Marriage Act, and the Reshaped Act. In all these acts, we have this different maintenance provision. So the question which comes in our mind is whether she will be entitled for the maintenance in each and every act, or that is there any other procedure. So for this we have this very famous case, that is the Rajneesh versus Neha. This is also very the landmark judgment, and where the Supreme Court gave the certain guidelines related to the maintenance, where they ruled that it's not that in each and every act she will be entitled for the maintenance. What the guideline says that the amount which she will be getting throughout her maintenance period, it will be set off. That is, for each and every act will be seen, and the maintenance amount will be seen, and accordingly the amount will be set off, and the overall this after the culmination the maintenance order will be passed, and the particular amount related to the maintenance will be given to her. So it's not that for each and every act you will be getting the maintenance, but after setting of the maintenance amount, the whole sum amount will be depending upon the cases, that whether it will be whole sum or it will be in the installment. But the thing is that the set of amount will be seen after going through all the acts, or after going through all the amount which are there, you will be given the maintenance, and making the set of things, you will be entitled for the maintenance. So this was what the Rajneesh versus Neha and another case, another hold. And the related to affidavit thing was like at times we see that the husband conceal the earning amount. Similarly, wife also, and we have seen the second cases, the wife also hide the earning amount. So for this also we have this guideline which says that they will be entitled for they will be they have to file the affidavit related to the amount which they are earning of the profit which they are getting. Then only the maintenance order will be passed. So all these cases were there, which was there related to the maintenance. So from all these cases which we can say that the fundamental points which are there, which need to be remembered, is that the section 125 is the remedial provisions, and it aims to prevent the destitution, and it is to be interpreted liberally, not that the strict provisions, strict interpretation need to be given. It should be interpreted liberally, and the person who is claiming the maintenance must show that she is unable to maintain, that is the inability to maintain themselves, and the respondent need to prove that he is unable to pay. That is, if we talk about the wife, she will have to prove that she is unable to maintain, and if we talk about the husband, that is the respondent, he will have to prove that he has inability to pay. So this need to be proved in order to settle the maintenance. Now the third is the earning by wife is considered. This, as we have seen, that even though the wife is earning, but that the earning is not an absolute bar. That is, the earning should be such that it is sufficient for her life. That is, the life which she was accustomed to, the standard of living, the amount should be